Hello everyone, I am Leanne D'Souza. In this brief presentation, we will be delving into the Protection of Children from Sexual Offences Act 2012, which is POCSO for short. The following discussion is being conducted under the Pan-India Legal Literacy and Legal Awareness Program, which is a joint initiative of the Centre for Environmental Law, Education, Research and Advocacy, National Law School of India University, Bangalore, and the Department of Justice, Ministry of Law and Justice, Government of India. Now let's get started with the Act itself and look into a few salient features. The first question that probably arises with respect to the POCSO Act is, to whom is this Act applicable? The POCSO Act, as the name suggests, is a special law that was formulated to provide protection to children. So who is a child? A child is any person who has not attained the age of 18 years. That is, any person who is below the age of 18 years will be afforded protection under the POCSO Act. Interestingly, the Act is a gender-neutral legislation. This means that the Act is applicable to any child of any gender or sexual orientation. Furthermore, the Act is not only restricted to children of Indian citizenship. Rather, the Act also applies to children of any citizenship other than India if the offence under the Act has been committed within the territory of India. The next question that arises with respect to the POCSO Act is what kind of protection is guaranteed to the child. Under the Act, protection is afforded to the child by categorizing certain acts or certain commissions or omissions as offences which are punishable under the Act, which can include imprisonment up to the time period of 20 years. So what kinds of acts are considered to be offences punishable under the POCSO Act? The POCSO Act primarily punishes any kind of abuse, assault, or harassment of a child which is of sexual nature. This can include physical contact with the child which is of sexual nature, or any physical contact which is done with a sexual intent. Any word, sound, or gesture which is done with the intention of having heard or being seen by the child is also covered under the Act. Forcing a child to exhibit his or her body is also punishable under the Act. Certain activities like stalking, constantly following, watching, or contacting the child, which can be done through telephonic means, social media, digital means, or even electronic means, is punishable under the Act with imprisonment. Some of the grave offences includes child pornography, and this can include enticing a child or even using a child for any pornographic purposes with or without the consent of the child. Attempt to commit these offences is also punished under the Act, as a child is given special protection. Apart from attempt, abetment to commit these offences, which includes instigating any person to commit an offence under the Act, engaging any other person to commit an offence, or even facilitating the commission of any act which is punishable under the POCSO Act, is also punished under the Act. Furthermore, the media is also vested with a responsibility and the duty to preserve the identity and confidentiality of information pertaining to children in relation to any offence under the Act. In other words, disclosure of a child's identity, which can include the child's name, the child's address, the family details, the school, details about the neighborhood of the child, disclosure of any such information by the media through any means whatsoever is also punishable under the Act. Now that we've looked into the kinds of protection available to a child under the Act, let us delve into the grievance redressal mechanism that the Act provides for. Under the POCSO Act, any offence that has been committed can be reported to the police by filing a complaint or by filing a first information report. So who can file a complaint under the Act? The child, the child's parents, or any person who has an apprehension or who has been witness to the commission of an offence or who has knowledge of any offence being committed under the POCSO Act must necessarily report such incident either to the local police or to the Special Juvenile Police Unit, or they can bring this information to the notice of various authorities like the National Commission for Protection of Child Rights. So, in the event a complaint is being filed, what procedure is required to be followed under the Act? The procedure provided is quite simple. Information regarding any offence committed under the Act can be made in person at the police station. This means that any person can go physically to the police station, which is of the closest proximity, and make a complaint, or the complaint can even be made over phone by contacting the police. The complaint that has been made can either be made in writing or it can be made orally. However, the Act mandates, in other words, it is compulsory that any complaint that is made orally has to be reduced in writing by the police inspector taking such information or recording such first information report. Furthermore, any complainant making such a complaint or providing such information regarding the commission of any offence has a right to get a free copy of the FIR or the first information report. This is a right which has been explicitly provided under the Act, and there is no charge for getting a free copy of the FIR. As the POCSO Act has been formulated to provide special protection to children who are considered to be very vulnerable, there is a mandatory reporting system. In other words, any person who has knowledge of the commission of a particular act or who has seen or has witnessed a particular offence being committed under the Act must compulsorily report the same to the police. And in the event they do not report the same, such person can be punished with imprisonment which can go up to 6 months or with a fine. If a child wishes to make a complaint himself or herself regarding any offence committed against the child, there are special procedural protections available to the child under the POCSO Act. So, what are these protections? The first is that if the child wishes to make the statement can be given at the residence of the child and not necessarily at the police station. This means that if the child wants to make a complaint, the police officer who records such complaint must necessarily go to the residence of the child or any place that the child chooses. This is to ensure utmost comfort and ease of the child. Secondly, the statement must preferably be taken by a woman police officer whose rank is not below the rank of a sub-inspector. The police officer recording such statement should not do so while wearing a police uniform. The POCSO Act was crafted for the purpose of ensuring complete protection to the child, and in order to ensure that the child makes such complaint or makes such statement under no compulsion or under no coercion, the police officer is required to make the statement when not in police uniform. The statement of the child must also be recorded and read over to the child in simple language or in a language that the child understands. In other words, after recording the statement, such statement or information should be read over or repeated to the child so that the child is aware of the content being recorded. Furthermore, the child also has a right to have a social worker present at the time of making such complaint. This is to ensure that the child has certain support in the form of certain social workers who are helping the child in making such complaint under no compulsion or under no threat. Furthermore, the child cannot be forced to go to the police station and cannot be detained in the police station at night. If the child is forced to do so, the complaint might not be made under a bona fide intention. Besides filing a complaint under the Act, the child is also entitled to other statutory rights which are explicitly provided under the POCSO Act. Some of these rights are discussed as follows. The first right is a right to be represented by a lawyer. For any offence committed under the Act, the child has a statutory right to be represented by a lawyer of his or her choice. This means that the parents or the guardian of the child can seek legal assistance of any lawyer of their choice for the purpose of trying an offence under the Act. However, in the event the parents or the child's guardian does not have the means to avail legal assistance, then the State Legal Service Authority or the District Legal Services Authority can assist the child or his or her parents in availing legal assistance. The second right available to the child is the right to anonymity. This means that the child has a protection to his or her identity. In other words, during the course of investigating or trial of a particular offence under the Act, the child has a right to be protected in terms of his or her identity. This means that no person, including the media, shall divulge or disclose the identity of the child, which includes the name of the child, any photograph, the address, the details of the parents or family of the child, the school, the neighborhood, or any such personal information which may reveal the identity of the child. In the event any person or any media house or any owner of such photographic material divulges or discloses such information which relates to the identity of the child, such person can be punished under the Act. The next right is the right of the child to avail police protection. During the course of investigation, to ensure complete protection of the child and to avoid any instance of coercion or compulsion, the child has a right to be protected by the police from the accused or any associated person of the accused. This means that during the course of the investigation or during the course of the trial of any offence under the Act, the child is entitled to avail police protection from coming in contact with the accused or any person who is directly involved in the commission of the offence. Furthermore, during the course of the investigation, the child also has a right to have a social worker present during the entire course of the investigation. The child is also entitled to have an interpreter or a translator present during the investigation to ensure that any information being disclosed, any statement being given, or any direction or any questions being posed by the police are understood in a language or in a simple language that can be comprehended by the child. This means that at the time of the investigation, if the child would want to make a statement or the child would want to record any information, then the child has a right to have a translator or interpreter present at the time of divulging such information or giving such statement. This is to ensure that the information being given by the child is completely understood by the child and is also given freely under no duress or no coercion by the child. Furthermore, during the course of the trial, any evidence that is being recorded can also be recorded in the presence of a social worker or in the presence of a translator in the event the child would want to make a statement that is marked as evidence in the course of the trial. The next right that the child has is a right to urgent medical and psychological treatment. In the event the child has been subject to any assault, harassment, or abuse under the Act, the child has a right to be treated or to be examined by a medical expert, and such medical examination shall be conducted in a hospital run by a government. And in the event such medical expert is not available, then the child can be examined by a medical practitioner who is a registered medical practitioner and to whom the child shall be sent without any delay. The examination shall be conducted with no delay, and the particulars of the child that should be given include the name and address of the child, the name and address of the person who has sent the child for medical examination, the age of the child, the description of any material taken from the person of the child, any marks or injuries that are visibly seen on the child, general mental state or mental condition of the child at the time the child is being treated and admitted, and any other material particular details which is reasonably required in the course of the investigation or the trial of any offence. During the course of the medical examination, the child has a right to have his or her parent or guardian or any other person in whom the child reposes faith and confidence to be present during the course of such medical examination. In case of a girl child, such child has a right to be examined by a female doctor. Apart from having the child's parent or guardian or any such person in which the child reposes confidence, the female child may also have any female employee or female doctor nominated by that particular medical institution to be present during the entire course of the medical examination. This is to ensure complete comfort and ease for the girl child during the course of medical examination. Another right available to children under the Act is a right to be protected from false complaints. This means that in the event a child makes any false complaint under the Act, the child cannot be punished either with fine or with imprisonment. This is to ensure that children are not inhibited or children are not prevented from making any complaints in terms of any abuse, harassment, or assault under the Act due to fear of any form of punishment. Another social welfare right that has been provided under the Act is a right to compensatory relief. Such compensatory relief, apart from monetary form, can also be given in the form of food, clothes, or transport to the child. This is to ensure that the child who does not have the means to avail such minimum needs will be entitled to secure such claims in the form of compensatory relief. The last right available to the child is the right to secure special care and protection. Under the Act, if the police or any special juvenile unit is of the opinion that a child against whom an offence has been committed under the POCSO Act is in need of special care and protection, then such police officer or the officer of the special juvenile unit should prepare a report recording its reasons or opinions in writing, stating that such child should be sent to a nearest home or to a nearest hospital to secure such special care. After recording such report, the child should be sent within 24 hours to the nearest hospital or nearest care home where such child can avail special care and protection. This is to ensure that in certain exceptional situations where the child is undergoing certain mental trauma or certain physical injury, then the child should avail special care and special protection without undue delay. Apart from filing a complaint to the police under the POCSO Act, there are other mechanisms or other methods through which an offence committed under the Act can be reported. First and foremost, a complaint regarding any offence committed under the POCSO Act can be made to the National Commission for Protection of Child Rights. As this commission has been explicitly set up for the protection of children, a complaint can be made in person directly to the commission, or it can be done over telephone or through post. So who can file a complaint to the National Commission for Protection of Child Rights? The child himself or herself, his or her parents, guardian, or any other person who has knowledge of the commission of a particular offence, or who has witnessed the commission of an offence, or who has apprehension that an offence under the Act is going to be committed. Such person can report such abuse, assault, or harassment that is about to take place or has taken place to the NCPCR. And how can they do so? The complaint can be filed online. By going to the website of the National Commission, there is a POCSO e-box, which is a dedicated web page for filing complaints under the Act. Besides this, a complaint can also be made via telephone by calling the toll-free number, which is 1800115455. The child helpline, which is also available at the national level, can be used for the purpose of making a complaint over telephone. The child helpline for any offence, whether it is under the POCSO Act or otherwise, against children is 1098. By dialing this number, an offence under the Act can be reported directly to the police or to the authorities. In the event any person would like to make a complaint in writing, such complaint can also be posted to the National Commission for Protection of Child Rights to the address given on the slide. In these ways, the protection of a child against sexual offences or any actions of sexual nature which are punishable under the POCSO Act can be redressed. As this Act is a comprehensive law and has been formulated specifically for the protection of children under Article 15 of the Constitution, it is not only the right of a child to be protected, but also the duty of each and every citizen to protect the child or protect children in India by reporting such complaints to the police or in the manner specified in this discussion today. We hope this discussion has been fruitful and helpful in understanding the various ways in which a complaint for any offence committed under the POCSO Act can be filed. For more information on various topics and the rights and duties under various legislations, do subscribe to our YouTube channel. Thank you.